Good morning.
Is it my understanding, am I correct in understanding that prior to this case, you've had 3 cases involving so-called homicide by heart attack?
I've had 3 similar cases with similar causes of death, yes.
Okay. I want to ask you some questions about an unrelated case.
Okay.
Were you the medical examiner in a case that was charged in Lowell District Court in 2020 involving motor vehicle homicide that involved a defendant named Kevin Francis?
I'm not familiar with the defendant's name. I would be familiar with the decedent's name.
Can you show her the decedent's name? And Doctor, I'd ask that you don't repeat the name aloud, please.
Absolutely.
Second paragraph.
Yes, I am familiar with this case.
Now, without going into any detail, specific detail of that case, it's fair to say that after you initially conducted your evaluation as a medical examiner in that case, you formed an opinion as to both causation and manner of death, correct?
Yes.
And the case involved a finding that, and without going into great detail, if I may, it just had to do with the victim, the deceased, being struck by a motor vehicle while he was attending to another motor vehicle in Massachusetts, right?
The original death certificate, yes, that is correct.
And then approximately 2 years after being struck, he passed away.
Yes, I believe that's the timeline.
And then, based on your evaluation as the medical examiner, you made particular findings as to causation and manner of death.
Yes.
And after you did that, you were made aware of additional information that had to do with the type of disease that the deceased had experienced and had in fact succumbed from, had died from, correct?
Yes.
And after you received the additional information from a doctor named Stephen Arnold, you changed your causation and manner of death.
Yes.
And you changed the manner of death to undetermined from, you changed it to undetermined.
Yes.
And that was, so in conclusion, what you did was you made an opinion as to manner of death without all of the information that was available, and then once you were made aware of that information, you then changed your manner of death.
That's correct.
And you would agree that the information that you were made aware of had existed at the time that you made your original manner of death?
Yes, it existed, but I was not made aware of it.
Okay. And that's all.
Thank you.
Yesterday, toward the end of my cross-examination of you, I pointed out the specific language in the guide that has been referred to repeatedly, that vigorous verbal argument should not be a basis for making a determination of manner of death as homicide in these types of cases. Do you recall that?
Yes.
And in fact, the citation that I showed you in the guide was in the comments section, correct?
I believe that's the case, yes.
And it's fair to say that in the guide itself, it explains that before the guide was promulgated and published, that it solicited comments from other forensic pathologists and incorporated those comments into what the guide then became, correct?
Yes?
So what was stated and included and attached as the appendix to that guide that's been admitted into evidence, those comments were considered in coming to the, for instance, writing that paragraph number 28 on page 13, weren't they?
I believe so. I wasn't involved in the writing of the classification.
So it's fair to say that the guide includes a statement that says vigorous verbal argument is not the basis for determining a manner of death in one of these cases.
When it is outside of the activities of daily life.
Okay. And we've already asked, you already said, testified that you're unaware of what, quote, the normal daily life was between Ms. McGee and Mr. Savitz.
Correct.
I'd like to return, if I may, to some of those questions that I asked you about the Turner article and the issue of criminality and intent. You stated yesterday under oath that the Turner article revised the Davis criteria, correct?
Yes.
And you said that, if I understood your testimony correctly, that the Turner criteria, the 5 criteria, can now be applied to instances of where there is both just a severe verbal altercation as well as where there is some evidence of physical contact.
Verbal and or physical contact, yes.
It didn't do away. You're not suggesting that it did away with the Davis criteria.
As an update, it supplants the original criteria. It's considered an update, a modification.
Okay, but my question to you is, you're not suggesting that now the Davis criteria can't be referred to, are you?
They could be referred to,
Okay.
but there are updated criteria.
And the updated criteria, when you say that, as was explained in the Turner article, if you recall, was because now Turner went on to say, let's talk about when there is in fact physical contact between the two acts.
I would have to review the articles again.
In any event, you stated specifically on direct examination that the factor 1 that's included in the Davis article from 1978 and the factor 1 that's considered in the that's set forth in the Turner article of 2004, that the word criminal is left out of the first factor.
Yes.
You're not suggesting, are you, that Dr. Turner was suggesting that with regards to these types of manner of death determinations, that you don't need to consider criminality of the perpetrator?
I am saying that the revised guidelines don't necessarily imply that there was a criminal act.
I didn't mark this completely, whatever exhibit the Turner article is.
So they were right there.
Okay, thank you. I'm showing you now, Dr. Dedrick, what's been marked Exhibit 68.
Mm-hmm.
I'm not asking you to read out loud, I'm just going to read it, and I want you to follow along to make sure that I read it correctly. Pointing your attention to page 2, the very bottom of the first column. Dr. Turner states, when the stress is precipitated by criminal activity or other acts of aggression directed against the victim by another person, it is appropriate to consider these deaths as homicide, correct?
Yes.
Dr. Turner, in that sentence in his article, as he begins to discuss his factors, specifically states then that when the stress is precipitated by criminal activity, correct?
Or other acts of aggression.
Are you saying that it's your interpretation that the word "or" removes criminal activity from the context of factor 1 in Turner?
I am saying that either of those are now options using the word or.
Well, you would agree that specifically, now I point your attention to the top of the second column of that same page, Dr. Turner's first factor is the action of the perpetrator toward the victim should be of such severity and have sufficient elements of intent to frighten, injure, or kill. Correct?
Yes.
Sufficient elements of intent to frighten, injure, or kill. Doesn't that tell you he's talking about criminal activity?
No, it's intent to frighten, injure, or kill. I don't understand what you're asking.
I'm asking you, is it your opinion as a medical examiner, when you apply these factors, the 5 factors of Turner, if you do, that these factors apply to someone who is doing nothing more than innocent, non-criminal behavior?
You know what, I'm gonna see what that's in.
Dr. Dedrick, I want to focus your attention to the second sentence, or the sentence that follows the sentence I just read you, and it's at the top of column 2, right below table 1. Dr. Turner then says, in order to appropriately certify such deaths, talking about once again, are you with me?
I am, yes.
Strict criteria, such as those set forth by Davis, should be satisfied. It's fair to say that Dr. Turner, in his discussion of his factors, he's once again incorporating the strict criteria of the Davis factors, right?
Yes.
And the Davis factor, number 1, includes reference to criminal conduct, correct?
Yes.
Okay. Now, I will now focus your attention to page 3, the last page. And I want to focus your attention to the first full paragraph in the second column that begins with the 5 cases. And I'm going to focus your attention now on that second sentence. The stressful event related to criminal activity. The stressful event related to criminal activity can be described in various ways on the medical examiner's documents. I'm paraphrasing now. But Dr. Turner specifically states the stressful event related to criminal activity. He once again refers to criminal activity, doesn't he?
Yes.
Okay. Now, finally, the very last sentence that Dr. Turner says on page 3, in the final paragraph, finally, he says, appropriate certification may lead to successful prosecution of criminals. Correct?
Yes.
It is fair to say, it is accurate to say, that Dr. Turner is still dealing with criminal activity by the perpetrator, isn't he?
Yes.
Thank you. Yesterday, toward the end of cross-examination for the day, I withdraw that question. Throughout your cross-examination yesterday, you recall continuing to refer to perception
In what context?
in the context of the perception of the deceased?
Yes.
As to fright?
Yes.
And you also referred to multiple times to the perception of the victim as to the intent of the perpetrator, correct?
Yes.
So, what you were saying, and you correct me if I'm wrong, that in this case, you decided, based on what was presented to you, primarily the Brookline Police Department report from Officer Yanez, that included the statement of the daughter, correct? That you
Yes.
relied on. That you then made a conclusion that the deceased perceived an intent on the part of Miss McGee, correct?
Yes.
And you also said that you determined that the deceased perceived fear, correct? That's what you testified to.
Yes.
There is, you would agree that that is a problem, isn't it, for medical examiners making their own assumptions about what a victim perceives, correct?
No.
I want to focus your attention on what has been marked,
That's yours.
what's been marked exhibit, well, it looks like it's ID only. ID O.
And what is it?
It is the manner of death certification after significant emotional stress, 2018.
Yes.
And at this time, I'm going to move to introduce exhibit for ID O into evidence.
Are you objecting?
No, yeah. Exhibit 69, so marked.
While I'm here. I want to focus your attention on the lower part of column number 2 in the first full paragraph. Now this,
I'm sorry, give me 1 second. You said the lower part.
in column 2,
Column 2.
and I just want to direct your eyes to the lower part of the first full paragraph, the beginning, the sentence that starts the possible discrepancy.
Give me yes.
703. Oh, I handed it to you, and I'm sorry, I didn't. Are you there?
I'm all set. Yes.
And once again, now what's been marked as an exhibit was published by the National Association of Medical Examiners, correct?
Yes.
And you're familiar with this article, correct?
Yes.
And in this article that's dealing with these types of determinations of manner of death, the authors say the possible discrepancy between real and perceived danger is another major factor affecting certification. In the comments of the case, and I'm not going to read that, I'm just going to jump down to the next sentence that says, anxiety, panic, and perception of danger can occur for any reason or no reason at all. The subjective nature of danger perception requires interpretation of investigational evidence, making certification controversial and unpredictable, correct?
Yes.
The authors are simply saying that when someone subjectively tries to determine what a victim might have been perceiving with regards to fear or fright, that's problematic, and it makes certification controversial and unpredictable, doesn't it?
This is referring to this one case, which is different than the case of the decedent that we're discussing. Case number 4 had different circumstances.
Well, he doesn't distinguish. Wait. Where in this entire paragraph, where the authors start, we're talking about certification of an unnatural manner of death. And just by the way, when that word unnatural is used, can you explain to the court what they're talking about is there's no category, there's no classification of unnatural, is there?
No, it is everything besides the manner of natural.
Okay. So it includes homicide.
Yes.
And that's what the paragraph is talking about, right? It's talking about certification of unnatural manner of death after stressful events requires a strong association between an intense stressor and death, correct?
Yes.
And not only do they use as an example that case number 4 that has to do with the robbery, but they also reference case number 8, correct?
Yes, they do.
But there's nothing in this paragraph that talks about the subjective nature of danger perception requires interpretation of investigational evidence. They don't say that only applies to these type of scenarios. They just use those as examples, but they are telling the reader there's danger in perceiving things that might not have occurred. Aren't they?
Yes.
Yesterday, you did state under oath that anger can result in the rush of hormones resulting in a cardiac event, correct?
Yes, any strong emotional response.
And you told us also on cross-examination that there is no way to distinguish between whether someone who becomes angry, if their own anger caused the rush of hormones, or if it was the conduct of someone else at the same time.
Yes.
So, you would agree, and as you did yesterday, you would agree that the rush of hormones at issue in this case could have been only the result of Mr. Savitz's own anger, correct?
There were 2 people involved with the discussion. Yes,
So yes, meaning yes, it could be.
it could be.
Okay. Are you familiar, and may I approach, Your Honor?
Yes.
Are you familiar with this article by Rachel Lampert?
I am, yes.
Do you?
I don't have a copy.
You don't have a copy? Why don't I read that for you?
Thank you.
If we could have that marked for ID.
Thank you.
I'm sorry, Judge, I don't have an extra copy.
IDP, so marked?
Without going into great detail, it's fair to say that article isn't dealing with manner of death in these types of cases, right?
Correct.
What that article explains is that clearly that anger and a variety of different forms of anger can trigger cardiac events, correct?
Yes.
And it also goes on to talk about that someone's response to anger can be genetically based, correct?
I don't recall that in the article.
Can you turn to page, I don't know the number, but I think it's page 3 in the pamphlet. And since it's my copy, I think you'll see a highlight.
There is a highlighted section, yes.
And is that the page, if my memory serves me, that deals with the comment about genetic predisposition?
The line that is highlighted does not say,
Why don't you take a minute and just read through?
if there's something that you would like to direct my attention to.
Page number, it's marked number 50. Okay. Start at the last paragraph on column 1. I apologize. Once again, pointing your attention to the bottom of column number 1. That is where Dr. Lambert talks about genetic predisposition and how it affects the hormonal response, correct?
Yes, it does.
And so, not only do we have anger alone can be the precipitating event for a cardiac event, but as that piece of literature talks about, the type of response that someone might have in response to their own anger can be a genetic predisposition, correct?
Yes.
So, what we have here in this case, based on what you reviewed in the Brookline Police report that contained the statements of the daughter, that in fact, the anger that Mr. Savitz might have been experiencing could have been the precipitating event that caused his cardiac event.
Yes.
And in fact, based on that article, he could have been predisposed genetically to have that type of reaction that resulted in a cardiac event.
Yes, and as I have said repeatedly, it is the timeline and the circumstances that determine cause and manner of death.
Okay, let me ask you about that, since you just said it. You're not suggesting that it's just the timeline that leads you to the conclusion of manner of death.
Yes, that is what I'm saying.
Only the timeline?
In addition to pre-existing medical conditions and what was seen during emergency medical service and emergency room findings. That is the 3 parts of my cause of death.
Well, wait a minute. We're talking about the 5 factors that both Turner and Davis talk about. So temporal proximity, the timeline, that's factor number 5, right?
Yes, I believe that's number 5.
Okay, but there's 4 other factors, right?
Yes,
You're not saying that you ignore those other 4 factors. You're just saying that temporal proximity is one of the 5, correct?
yes,
Okay, so I'm sorry, I probably misunderstood you. That to reach a manner of death determination in cases like this, you need to consider all 5 factors.
yes,
And there's no doubt that temporal proximity, that is, that the cardiac event happening close in time to the precipitating event is an important factor.
yes.
But it's not any more important than to consider the other 4 factors, is it?
All of those factors are considered.
You stated yesterday that the injuries were not part of your causation finding.
That's correct.
In your causation finding, you make no reference to anything related to cerebral vascular issues with Mr. Savitz, right?
Not directly, but hypertensive and atherosclerotic disease incorporates that.
Well, okay. You're saying that since he, Mr. Savitz, had hypertensive or high blood pressure, correct?
Yes,
That could have contributed to the causation of death?
I said that. It's part of my cause of death.
Okay. And there are different categories of hypertensive or high blood pressure, isn't there?
Yes,
Well, are you familiar with essential hypertension?
yes,
Okay. And isn't essential hypertension the most common forms of hypertension?
it is one form of hypertension.
It's one form, but doesn't it exist in 85%, approximately 85% of people who have high blood pressure?
Yes, I am not sure what you're getting at.
I'm just asking you a question.
Yes,
Okay, so it's yes to yes, it happens quite frequently, 85%.
it is frequent. Yes,
And people live and survive and function with essential hypertension every day on this planet Earth, don't they?
yes, they do.
And you did not review, once again, any of the medical records of Mr. Savitz, did you?
Not
Other
be.
than the emergency room records.
That is correct.
And so are you aware that all he was diagnosed with repeatedly over the year starting 2018 was essential hypertension?
I did not know that diagnosis, but the findings at autopsy support hypertensive and atherosclerotic cardiovascular disease.
And once again, finally, you referenced diabetes in your causation, correct?
Yes,
But he didn't die from diabetes in this case, did he?
it was one of the factors included in my cause of death.
And people survive with diabetes day in and day out
Yes, they do.
all over the earth, correct?
Yes,
And you didn't see, because you didn't look at, anything in any medical records that demonstrated that he had complications of diabetes mellitus, did you?
again, there were findings at autopsy that supported the diagnosis of diabetes mellitus.
I'm really not trying to argue with you there, but just, I think this is going to be my last question.
Okay.
It's the same question I asked you yesterday about determining cardiac disease and the severity of it. You only determined the diabetes issue and connected it to his causation. I shouldn't say connected it to the causation in this case, only after you conducted your internal autopsy, correct?
Yes,
If there was a severe issue of diabetes in Mr. Savitz, someone looking on the outside, a layperson, would not necessarily know that, correct?
He did wear a continuous glucose monitor that was visible.
People wear continuous glucose monitors all the time that aren't suffering serious complications from diabetes, aren't they?
That is, depends on what your definition of severe complications are.
But did you read the medical records to see if he was having severe complications?
No.
Okay. I think that's all I have. Thank you, Doctor.
Dr. Dedrick, on cross, you spent some time discussing with counsel about the statements that that Ms. McGee made that were contained within the Brookline Police Report.
Yes.
Correct. I'm going to hand you what's been marked for ID, Exhibit letter N.
Thank you.
Dr. Dedrick, did you also have information, is Ms. McGee's statement regarding what happened the only information that you had available to you about what happened in the home that evening?
So this is the Brookline report. I also had the Massachusetts State Police report.
And in the Brookline report, is there a statement by Mr. Savitz's daughter, Susie Savitz?
Yes, there is.
And what information did you have from the police report regarding what Susie Savitz saw that night?
The report was a, quote, domestic dispute between her parents.
And what did Susie Savitz report, or what did the Brookline police report that Susie Savitz said happened?
Do you want me to report what was on the 911 call?
In the second paragraph on page 3 of the Brookline report.
I'm sorry.
And again, you had this report available to you before you certified the death certificate,
Yes,
correct?
I did.
So what information did you have about what Susie Savitz saw that night?
She said that she heard her parents arguing for about 10 minutes, that she asked her father to, she heard her father ask Miss McGee to leave. She then stated she went downstairs to intervene, and she could hear her father repeatedly telling Ms. McGee to leave. As she descended toward her parents, she witnessed her mother slapping her father in the face and chest with open hands. She then stated her father had his hands up trying to defend himself, and at this point she called 911 while they were still arguing.
So that information about Susie Savitz's father having his hands up trying to defend himself, that information, what if anything in your determining the manner of death would that information give you towards your opinion?
It sounded from that as though he was not the aggressor.
And was there, with regards to this perception of fear that you were talking about on cross-examination, is there anything about Susie Savitz's statement that would indicate to you that the deceased perceived some fear?
He was asking her to leave.
And what was he doing with his hands?
He had them up.
And in fact, Susie Savitz's statement indicates that this was more than a vigorous verbal argument, correct?
Objection.
Now, Dr. Dedrick, in addition to that information that you had from Susie Savitz, you also had the statement that Penelope McGee told the police, correct? And if you could
Yes.
turn these to page 2 of what's been marked for ID as letter N. It's what you have.
The one, okay. I am on page 2.
In that last paragraph, what did Ms. McGee tell the police about how the argument began?
I'm sorry, I'm not sure where you're looking. You said on the second page?
Yes, page 2.
I'm sorry.
This is actually your page 1.
Okay.
If you could just if I could just draw your attention to the second to last paragraph. Did you have information from this report about how the incident that night began?
From this, yes.
And what does it say in the second to last paragraph about how this incident began?
So reading from this, it says, according to Penelope McGee, she had arrived around 22:45 hours and sat down on the couch in the living room with her ex-husband to discuss an email she had received from him. She later divulged that the email was sent from Andrew Savitz to his brother, requesting the brother to permanently evict Penelope McGee from her residence. There's a typo, but from her residence, which the brother owns. Penelope McGee stated she was married to Andrew Savitz for 15 years, and they have been divorced for 6 years and have 3 kids.
And then in the next paragraph, does Ms. McGee indicate that an argument began to ensue?
Yes.
And what does the first sentence of that next paragraph say?
According to Ms. McGee, the discussion escalated into a verbal argument, and Mr. Savitz became belligerent toward her.
And this is Penelope McGee's statement, correct?
Yes.
So Ms. McGee herself indicates that a discussion escalated into an argument, correct?
Yes.
Now, Dr. Dedrick, that's not the only information you had about what had happened that night, is it?
Correct.
And you mentioned you also had a police report, a state police report
Yes.
available to you that contained information?
I did. Yes.
And Your Honor, may I approach?
Yes.
Doctor, I'm showing you this document. Do you recognize what this is?
Yes, I do.
What is it?
This is a copy of the Massachusetts State Police report.
And is this what you reviewed before you certified the death certificate?
I did. Yes.
Your Honor, I'd like to have this marked for IT, please. I think are we on Q?
Q.
Q.
So we Q so much? Thank you.
Dr. Dedrick, did you have an opportunity to review this? You had an opportunity to review this report, correct?
Yes.
Now, in this report, do you also have statements from Zosie Savitz?
Yes.
And in this report, does Zosie Savitz indicate that she observed her mother pushing and shoving her father?
Yes.
And that was while he was trying to get her to leave his residence?
Yes.
And you also had information in this report that Mr. Savitz had numerous health issues,
Yes.
and that he suffered a stroke 6 months ago,
Yes.
and that he suffers from diabetes,
Yes.
and that he had heart issues.
Yes.
And again, you had the medical records, and you were able to make your own observations.
Yes.
Now, Dr. Dedrick, the name guidelines that we refer to, both on direct and cross, are they generally accepted in the medical examiner community?
Yes, they are.
And how do you know?
How do I know that they're accepted?
Yes.
It's our national guiding organization, and in my training and my experience, they are often referenced in the Office of the Chief Medical Examiner when determining cause and manner of death.
And so you're aware that other medical examiners are familiar with these guidelines?
Yes.
I don't know if it's generally accepted, but what other people are aware.
Rephrase your question.
Do other medical examiners use these guidelines as a guide in conducting their autopsies and certifying their cause and manner of death? Have you discussed these guidelines?
Was there an answer?
Oh, I'm sorry. Yes, they are generally accepted at the Massachusetts Office of the Chief Medical Examiner.
And have you discussed these guidelines with other medical examiners?
In general, yes.
Now, your attention back to the guidelines.
I know, I'm not sure. I think they're in that pile.
Page 4. Do the guidelines indicate that death certificates may be changed?
I'm just looking to see where it says it.
I could draw your attention to the third paragraph, the second paragraph under other background information.
Yes, information on the death certificate may be changed if needed.
And under what circumstances would a medical examiner change a death certificate, information on a death certificate?
A death certificate is a scientific working document. If additional information comes out that changes the circumstances, that would be a situation where it can be changed.
So counsel had referenced on cross-examination that you had in a situation in the Lowell case where you in fact changed the death certificate.
I did, yes.
And that's because you had received additional information that wasn't available to you, correct?
Exactly.
But in this particular case, you did not receive any additional information, did you?
Correct.
And when you certified this death certificate, you used all the information that was currently available to you, correct?
Yes.
We've talked a lot about the classification of homicide as a manner of death that you certified in this particular case, correct?
Yes.
But I'd like to talk about the cause of death. It was brought up on cross, this concept of but for. Dr. Dedrick, with regards to the altercation that you had extensive information about prior to certifying your death certificate, with regards to that altercation, what is your opinion about what the cause of Andrew Savitz's death is?
The cause of death, as I signed it, is cardiac dysrhythmia following an altercation in a person with hypertensive and atherosclerotic cardiovascular disease and diabetes mellitus.
So is it your opinion, Dr. Dedrick, that but for this altercation, Mr. Savitz would not have died?
At that time, that is correct.
We have 1 minute, Your Honor. Dr. Dedrick, I would like to turn your attention to the Turner article.
Okay. I ended up with an extra copy of it.
Okay.
So I had it here.
Exhibit number 68.
I don't know whose that was.
If you could turn to page 2, please. The modified criteria. Dr. Dedrick, I'd like to just go down these criteria. The first criteria, which you talked a lot about in cross-examination, was the modified criteria, where the element of the criminal intent was removed by Turner.
Yes.
Criteria number 1, the action.
Objection.
Why don't you consent?
Dr. Dedrick, what is the first criteria for homicide by heart attack in the Turner article?
The modified?
Yes.
So the first one in the modified criteria is the action of the perpetrator toward the victim should be of such severity and have sufficient elements of intent to frighten, injure, or kill, either in fact or statute, so as to lead logically to a charge of homicide in the event that death resulted from physical injury.
What information did you have in the case of Andrew Savitz that met this first criteria?
As discussed previously, there was, based on the state and local police reports, frightening or the intent to frighten, to injure, or to kill.
And what was that information?
The description of the daughter describing how she had witnessed her parents interacting.
And how did she witness her parents interacting?
That her father's hands were up defensively and that he was asking Ms. McGee to leave.
And what is criteria number 2 in the classification of homicide by heart attack?
The modified classification is the victim should have realized that the threat to personal safety was implicit. A logical corollary would be a feared, threatening act against a loved one or friend.
And what information did you have from the Andrew Savitz case that satisfied that criteria?
Threat to personal safety.
And what was that threat?
Again, his hands were up defensively, as described, and he was asking Ms. McGee to leave.
And what is the third criteria in the Turner article for classification of homicide?
The circumstances should be of such a nature as to be commonly accepted as highly emotional.
And what information did you have that satisfied that criteria in the Andrew Savitz case?
There was discussion in the police reports that Ms. McGee had come over to discuss being evicted from a property, and then an argument had ensued from that.
And did you have any information about how help was summoned?
Just the daughter calling 911, is that what you're asking?
Yes, is that how help was summoned?
Yes.
And did you have any information as to when the daughter called 911?
Based on the police report, it was during the argument.
And what is the fourth criteria for homicide by heart attack in the Turner criteria?
The collapse and subsequent death, in most cases, must occur during the emotional response period, even if the criminal act had already ceased. In certain instances, death may be delayed, typically via medical intervention.
And what information did you have from the Andrew Savitz case that this criteria was met?
He was witness to collapse during the argument, and he died soon after the argument ensued.
And what is the fifth criteria in the Turner article?
Autopsy should demonstrate an organic cardiac disease process of a type commonly associated with a predisposition to lethal cardiac arrhythmia. In the absence of a grossly or microscopically identified organic cardiac disease, the case may involve a functional cardiac disorder, such as a conduction system disorder that has no atomic correlation.
And what information did you have from the Andrew Savitz case that satisfied this fifth criteria?
Twofold. One, the medical records indicated that he had a myocardial infarction or a heart attack, and also at the time of autopsy, I was able to see the hypertensive and atherosclerotic changes.
Now, Dr. Dedrick, is the information contained within this article generally accepted in the medical examiner community?
I believe so, yes.
Now, Dr. Dedrick, in the name guidelines, on page, if I could draw your attention, this. If I could just see
Of course. Here's yours.
Exhibit number 66. If I could turn your attention to page 13, that paragraph 28.
Yes.
In this paragraph, do the guidelines give hypotheticals of when the classification of homicide could be found with no physical contact?
Yes.
Could you give a hypothetical from this paragraph?
It says examples include someone who has an acute cardiac death while being verbally assaulted.
And is there another example of a verbal, of a situation where the incident is just verbal, but it may be classified as homicide?
So there's an example with an auto crash. There's an example of somebody being bitten, and then the last example as someone who dies suddenly when someone scares them.
And does it say or does it give an example of how somebody would be scared?
Popping up in a window and yelling, quote, boo.
So according to these guidelines, if somebody jumps up and yells boo, you may classify that as homicide?
Yes.
Now, further down in that paragraph, does it indicate when an argument could be classified as homicide, going beyond just verbal?
I'm not sure what you're asking.
The last the last sentence in paragraph 28. What does that paragraph say? That sentence.
The last sentence, starting with in general?
Yes.
I'm sorry. In general, the time interval to establish the causal relationship between, quote, minor injury, unquote, and collapse followed by death, or those involving acute cardiac deaths following fright, must be very short. During the stress-inducing episode or immediate emotional response period, a few minutes or less.
In your medical opinion, in the case of Andrew Savitz, was there minor injury?
There was minor possible injury to his face.
And how would you classify the length of time between when Penelope McGee was alleged to have been seen hitting Mr. Savitz and when he collapsed?
It was a short interval.
I have no further questions. Thank you.
Limited to the redirect, judges.
Yes.
Well, I don't understand why, but why did you leave out the last part of that sentence about yelling boo at somebody? Because it does say, with an apparent attempt to scare or instill fear. You didn't read that part, did you?
That was simply an oversight.
Okay. You understand, don't you, or do you, that an intent to instill fear can be a criminal act as assault? Do you know that?
Objection.
So I'm going to sustain that objection.
You said that you also had information about the 911 when you answered the question on redirect. In fact, the information you had on the 911 was contained in the police report, correct?
Yes.
And what it said was, Dad, stop, correct?
That is the way that it is written.
And that 911 call in its total would be available to you if you wanted to hear it, right?
Yes.
And are you aware of the fact that it's 4 minutes long?
No.
Okay, and you never bothered to listen to it?
That is not a typical thing that we do.
You just said you relied on the representation of the 911 that's in the police report.
I did, yes.
So why isn't it that the medical examiner conducting, as the literature talks about, a meticulous investigation to make this determination? Why didn't you ever bother to listen to the rest of the 911 call?
As I just said, that's not a typical thing that is done at the office.
But you could have done it.
Yes.
4 minutes of 911 call, right?
You just
You could
told.
have done that, right?
Okay, yes.
And are you aware of the fact that on the 911 call, the caller, who is the daughter, repeatedly or repeats, Dad, stop, Dad, stop? Are you aware of that?
I have read what is in the Brookline Police Report, as I have said.
And it doesn't say, Dad, stop, stop, stop. It says, Dad, stop, right? In
Yes.
other words, Dr. Dedrick, when you're considering Dad, stop, for instance, in this meticulous investigation to reach this manner of death, doesn't it matter to you then that the caller is directing her words to her father to stop whatever he's doing?
No. As I have said previously, there were two people involved in a discussion that became heated, and then the decedent passed away immediately following that. It does not matter who the perceived aggressor was in making my determination.
It doesn't matter to you who the aggressor was?
No.
It doesn't matter to you who started the aggression?
No.
It doesn't matter to you, then, who was actually more aggressive toward the other? It doesn't matter to you,
No, I've said that.
right? And yet the literature that we've been going over talks about the perpetrator and the aggressor and things like that, doesn't it?
Yes.
And it talks about the precipitating event being the result of what the aggressor does and what the perpetrator does, doesn't it?
And it refers to the victim, who is the decedent.
But wait a minute, doesn't it refer to what the aggressor does and what the perpetrator does in relationship to the precipitating event?
And as I have said
No,
previously,
can you answer that question?
those are the terms used.
And it refers to what the perpetrator and the aggressor do in regards to the precipitating event, correct?
Yes, in those documents.
But to you, it doesn't matter who is the aggressor or who's the perpetrator.
No. There are two police reports that have multiple pieces of information that were used in determining my cause of death.
When you say you were asked on redirect examination about this, what you characterize as a state police report, correct?
Yes.
Do you still have that in front of you?
I do?
Marked IDQ?
Yes.
You have no idea, do you, where that last sentence comes from? The victim has numerous health issues. That sentence. You have no idea what the source of that is.
No, I do not.
Okay, and in fact, even with this police report and with the Brookline police report, the only information about exactly how the event started was the statements of Ms. McGee, correct? How it started.
Meaning why she was at the house?
I didn't say why it started, I said how it started.
I'm really not sure what you're asking.
Really? Okay. You quoted on your redirect examination what Ms. McGee told the police, and she said they started a discussion, correct? Page 2?
Page 2 of the Brookline Police Report?
Yes.
Is that where you were looking?
Yes, no.
I'm sorry, exactly which paragraph are you referring to? I want to make sure that I'm looking at the correct spot.
The last paragraph?
On page 2,
Yes.
the last paragraph on my copy says a 51A was filed. Which one, where are you looking? I'm sorry.
May I approach it on?
Yes.
I'm looking on page 2.
This is my page 2.
No, you're looking at page 3.
Well, this is the second page in what I am looking at.
Okay, I understand your confusion. I'm just going to point out
Sure, that's
that
why I just wanted to make sure we're on the same
No,
page.
you're perfectly fair. This is page 3, so I'm going to show you, I'm just going to refer you now to what marked Exhibit N is, in Exhibit N, what is
Page 1. Excellent.
sequentially.
Okay.
Look at that last paragraph.
According to Ms. McGee, the discussion escalated into a verbal argument, and Mr. Savitz became belligerent towards her.
You also, in that paragraph right above it, you testified on redirect examination that she first came over to discuss an email she had received from him, correct?
Yes,
And you talked about eviction, correct?
that's what it says here,
What do
yes.
you know about the eviction? What do you know about it?
What is said here?
Do you know when the actual eviction occurred?
No, that I'm not something that I would be privy to.
Do you know if they'd had, do you know, in relationship to normal activities of two people who have been married for 20 years and divorced for 6, that they'd had multiple conversations about the eviction that had occurred?
No, again, that's out of my purview.
This state police report that you were asked about on redirect examination, that was authored by State Trooper Kukowski, right?
Yes,
And Kukowski was present for the autopsy, wasn't he?
he was, yes.
And in fact, did you ever see a 4-page report by Trooper Kukowski, regarding a further interview
No,
of Susie Savage?
this was the documentation that was provided to me.
So he was there at the autopsy, correct? He being Trooper Kukowski, right?
Yes.
Did you have a discussion with him about the content of his report?
No, that was 5 years ago. I could not tell you what was discussed 5 years ago in person.
Did you ask him if he had any other reports that you could review to conduct your meticulous and careful investigation of the facts before you reached your manner of death determination?
This was the report that was given to me.
This same report that you did have from Trooper Kukowski also includes, in an abbreviated form, the fact that Ms. McGee told the police that Mr. Savage attacked her, correct?
Give me a moment to review this, please. Yes, in the second paragraph it says that.
Okay. So yesterday you told us on cross-examination that you do not ignore all of the facts and all the reports and the information in the reports that you receive and you review before you determine your manner of death, correct?
Yes.
So it's fair to say that when you were asked these questions on redirect examination, that in fact you're not using the fact that Miss McGee had told the police she was attacked by Mr. Savitz, are you?
As I've said previously, there were two people involved in the discussion, and the end result is that one of them passed away. The forensic definition of homicide is two people involved in a death.
And those questions you were asked on redirect examination about perceiving fear, once again, that's your conclusion, correct?
Yes.
And that's one of the things that we've already discussed in that manner of death article, the problem with making subjective determinations of whether the victim perceived fear or not, correct?
Yes.
But you went ahead and did it.
I did.
You would agree with me that holding your arms up in the fashion that's described in the police report that you were asked about on redirect examination, that doesn't necessarily imply fear, does it?
The way it's described is a defensive position.
But it doesn't describe whether he was feeling fear or not, does it?
No, but we know he had an emotional response.
That could have been from his anger alone.
Yes.
You also were asked on redirect examination that the Brookline Police Department report you used the phrase intent to kill. It had information about intent to kill. Where's that?
You're misquoting me. It is three separate pieces that say, so what that is referring to are the Turner and or Davis guidelines, which say frighten, comma, injure, or kill.
Well, I apologize if I'm misquoting you. Thank you for correcting me. But you would agree, wouldn't you, that nothing in the Brookline Police report suggests anything about intent to kill, correct?
No.
And there's nothing in the Brookline Police report that even says specifically that Ms. McGee intended to frighten Mr. Savitz.
Yes.
Yes, meaning no, it's not there.
Correct.
Once again, that's one of your assumptions, correct?
Yes.
And you were asked on redirect examination with regards to factor number 2 of Turner, where it talks about the victim should realize fear. There's nothing in the police report of Brookline or the state police report you referred to on redirect examination that says Mr. Savitz realized or felt fear, correct?
The second criteria says should have realized the threat to personal safety. It does not say it the way that you just said it, with all due respect.
There's nothing in the police reports that say that's what Mr. Savitz was experiencing.
With all due respect, the decedent can't answer that. Therefore,
No, we can agree to that. My question wasn't that, Dr. Dedrick. My question was, you are making assumptions about what happened based on one narrative in a police report, right?
there are two narratives, and there are two separate police
Exactly.
reports.
You're not relying on the second narrative, are you? You're not relying on the second narrative where Mr. Savitz reportedly attacks Miss McGee. You're not relying on that, are you?
As I have said previously, there are two people who were involved, and I've said that multiple times.
If Mr. Savitz is attacking Miss McGee, he's not in fear, is he? He's attacking.
How do you know that that is not from fear?
How do you know?
I don't.
You're the ME.
I am making an assumption, as
You're
you
making an
said.
assumption based on your subjective analysis, right?
I am making an assumption based on my extensive history as a board-certified forensic pathologist with experience.
But don't you have to rely on the circumstances of the event, as all of the literature and as the 2018 manner of death article that we talked about specifically says? The answer is in the circumstances of the event, not the autopsy, correct?
And the circumstances of the event were taken into consideration when I made my determinations.
Did you take into consideration that the SPDU report, the state police report you were asked about on redirect examination, and the Brookline police report that you were asked about, that there are differing facts with regards to what Susie Savitz supposedly told police? That she said slapping to the Brookline police, that she said shoving to the state police? Did you take that into consideration?
I don't understand how those differences would affect my cause of death. There's
Your cause of death or your memory?
both. They're intertwined. Slapping or shoving or verbal, those separate pieces don't change the cause of death.
And finally, you said it on redirect, I believe, and you said it here. Your assessment as the medical examiner comes down to if there's two people in a room and one person attacks the other and dies, the other person in the room can be responsible for that person dying.
Objection.
Ask it differently.
You have, it's your opinion, your medical examiner opinion, that if two people are in a room and one person attacks the other person, and the person who attacked that other person collapses and dies, that the other person can still be named in a manner of death as responsible for it.
Objection.
That's not quite what I let you know.